Let's dig deeper into some of the possible impacts of this draft opinion. Should it become a permanent opinion, as we're joined live by Mitchell Hamline Law School professor Laura Hermer. Laura, let's start with what Heather and Pauline were discussing, the state of Minnesota's laws. If Roe were overturned, abortion protected in Minnesota?
Yes, abortion would, for now, remain protected in Minnesota. It is protected, as you noted, through Doe versus Gomez, Minnesota Supreme Court case based on the Minnesota Constitution, the state constitution, not the federal constitution.
Would you expect, though, Professor Hermer, that more people from other states would come to Minnesota to receive abortions?
That is absolutely expected, and abortion providers are already have been in the works now. They've been preparing for this because, of course, North Dakota and South Dakota, both of them have so-called trigger laws, laws that will spring into effect if and when Roe and Casey are in fact overturned. Abortion will be banned in those states. There's an old ban that exists in the state of Wisconsin, and then in Iowa, abortion is presently protected by a state Supreme Court case there, but the governor is presently working on trying to change that.
If this political report of the draft report ends up being the final opinion, there's a lot of ifs there because we don't know kind of how this is all going to shake out. You've been studying this issue. What do you see happening? Could the U.S. Congress take up a national law, or will this just be a state-by-state patchwork of rulings?
Arguably, the Congress could take this up, and Congress has legislated with respect to abortion in the past, with respect to the so-called partial birth abortion ban, the intact dilation and extraction prohibition that exists at the federal level. There have been several other instances where Congress has legislated on this issue, but I would expect, given the gridlock in Congress, I would expect to see this go to the states, and this is going to be hard fought at the state level in many states.
You look at this draft opinion written by Justice Alito here, and some of the legal reasoning. He calls that the Roe decision exceptionally weak. What is your thoughts on sort of some of the legal issues and legal arguments that are at play here?
Sure. So it's an interesting notion that Roe is exceptionally weak. The Roe court very carefully looked at the history of abortion in the United States, and actually before the U.S. existed, and came to the conclusion that even though it was not, until, as the draft opinion points out, the mid-1800s, it wasn't prohibited in many U.S. states. It wasn't prohibited anywhere in the United States. It also wasn't protected. And this is largely because abortion was a women's issue. And women were not a group, and are not a group that has particular power. Certainly did not have power at the time that the court is looking at. And so you wouldn't expect to see protections for abortion at this particular time. It would be like looking for legal protections for enslaved people or for Chinese immigrants in California.
Yeah. Just wasn't part of the dialogue in the 1700s, 1800s, for sure. Mm-hmm. Yeah. Mm-hmm. Laura Hermer, Mitchell Hamline Law School professor. Thanks so much for your insight this morning. We appreciate it.
Thanks so much for having me.